Muted. Sorry, guys, I'm muted. We have a jury question. That's what I was saying. So we're going to wait and see, or not a jury question. It could be a verdict. They sent a note. We're going to refresh this and see what exactly is going on whenever we get an update. But we're also going to get caught up with what we didn't look at yesterday. So yesterday's recap. So let's get over to Molly Roberts. There we go. The day 3 of the no more than 2-day trial of Sandwich Guy. The prosecution is resting its case. The defense hasn't decided yet, presumably if they want to put on a case. And there's a dispute over jury instructions and a few morsels, to follow. Firstly, Sandwich Guy does not plan to take the stand. Next, parties spent the morning haggling over definitions of, quote, assault, 5 other verbs the government can prove, and forcibly, the term forcibly. On assault, defense wants more to be required than just touching, offensive to a person of reasonable sensibility. There's also conflict over whether the defense could invoke the rule of completeness to admit more of the video of Sandwich Guy at police precinct. Specifically, part where he explains he believed the cops at the corner were about to conduct an immigration raid on an LGBT club having a Latin night. Now, this would be important because if the jury's tasked with deciding, sorry, I had it muted. My bad. That's why it looked like that in the beginning. Let's see. If the defense can get in front of the jury convincingly that, hey, his intent wasn't to assault and cause harm, cause physical injury to an officer, but rather to cause a distraction, then there's an extra area for the jury to consider when it comes to the elements of assault. The forcibly issue here hangs on whether any action, in this case, yes, the throwing of the possibly not exploding sandwich, must have carried a risk of inflicting bodily harm. And we're going to share a link here. This is Molly Does Independent Journalism. So in the chat is her link to where you can contribute to the work that she is doing. Also her X link if you guys want to just follow her over on X. And again, supporting is a great way, giving traffic to these tweets is a great way to show these reporters that we value the inside peek into the courtroom. We're still waiting for the judge to figure out the jury instructions. Definitions can take time. Thankfully, he need not rule on the distinction among hoagie, sub, and grinder. The defense is making a Rule 29 motion, which is a request for judgment of acquittal. Says at the very least, the government has improved 3 of the 6 magic verbs. Magic verbs. Defense also says that the remaining verbs besides assault, impede and interfere, Sandwich Guy actually helped the officers do their duty to the extent it was high visibility crime patrol and prevention. Indeed, they became more highly visible when officers arrested him in double digits. Because I think we heard there was previous reporting that there were 15 officers standing around when they apprehended Sandwich Guy. Judge denies the Rule 29 motion. Says a reasonable juror could conclude defendant acted forcibly and could conclude he performed any of the verbs. Finally, the Sandwich Guy speaks. Don't get too excited. All he says is yes, Your Honor, several times as to his decision not to testify on his behalf. Defense won't be making a case and will move for a Rule 29 again after it rests. The defense is emphatic about wanting to have the government close before lunch and the defense close after lunch. Looks like judge will have them both close after lunch. This way, no one will have the unfair advantage of having just consumed a fortifying footlong. Jury has its instructions. Must find Sandwich Guy acted forcibly, which can be shown through attempt/threat to inflict bodily harm. Assault is any attempt or threat to inflict any physical injury, however small, including touching offensive to a person of reasonable sensibility. So again, this would be if the attempt was to cause a distraction and not an attempt to threaten or cause a physical injury by, offensive touching, there's a different avenue for the jury to look at the evidence in front of them. Then they go off to lunch. Good news, the source says the food in the courthouse is not offensive to a person of reasonable sensibility. So then they come back, and let's do an update in real time before we get into the second half of yesterday. All right, so currently no note update, unless let's see if Molly made a separate tweet instead of making a thread, because sometimes that happens. Nope, no separate new tweet. And Also, no update from Celine. She just said that there was a note, but there's been no update since. So maybe they're having a very difficult time getting everybody into the courtroom. So we'll go back over to our afternoon recap from day 3. So they come back into court after lunch, and they're replaying the part of the bystanders video in which the guy filming cries out, "No, no, no, you don't gotta be Superman." We have reached the moment the footlong was flung. He spikes it, throws it like a baseball. It strikes Agent Larimore in the chest. He says he could feel it. Government acknowledges prosecution is not alleging he needed medical treatment. I'm going through the elements of the crime. So I'm assuming this is closing arguments. Okay, yeah, I skipped a tweet. I'm sorry. So the lawyer for the government's doing the closing. Michael DiLorenzo seemed to be having some sort of issue at the start, losing his train of thought and struggling to speak. He was buffering. Seems okay now. Going over the night's events with the CCTV footage as an aid. So there we go. There we go. That's how we get to this all. They're going through the elements of the crime, looking at the 6 magic verbs now, and the one even more magic adverb, forcibly. Here we have the defendant throwing. It's a sandwich, but throwing it hard. Assault now. Injury, government says, isn't the layman's definition, but the legal one. Hit with the sandwich, having a sandwich spiked on your chest. Is that offensive to a person of reasonable sensibilities? Certainly. We have an assault. Talks about sandwich guy impeding officer's mission. Displays quote on a slide. Quote, I did it. I threw a sandwich. I did it to draw them away from where they were. I succeeded. It finishes off by telling the jury that the officers focus on doing their job. Now we ask that you do the same thing. And then Molly adds here that in reference to Sandwich's guy statement about having thrown the sandwich, prosecution notes that he said it with pride. Now the defense. So defense begins. This case, ladies and gentlemen, is about a sandwich. A sandwich that, according to Agent Larimore, somehow both exploded on his chest in a spray of mustard and onions, but also landed intact on the ground, still in its Subway wrapper. A sandwich that Larimore testified he somehow felt through his ballistic armor on his chest, armor that is specifically made strong enough so that it stops a bullet from piercing a soldier's heart. Asks, would a man genuinely injured, genuinely offended by having a sandwich thrown at him proudly, happily, joyfully, keep a plush sandwich on his shelf and a felony footlong patch on, yes, his lunchbox? While the government prosecutes this case, quote, in some purported effort to keep law enforcement safe and free from food fights. CBP, so Border Patrol employees, are joking about it. The government, she says, is trying to turn a gag gift-worthy moment into a federal criminal offense. We ask you not to allow them to do that. Then defense goes to the definition of assault. Says it requires a reasonable fear of immediate bodily harm, and none exists given the agent's long-sleeve shirt, long pants, boots, gloves, and ballistic vest that is created to keep you safe from military rifle fire, and so is definitely going to keep you safe from a sandwich. They compare the incident to when an 8-year-old is in the middle of a bedtime temper tantrum and takes a stuffed animal with which he sleeps. They're making it a plush reference. And throws it at you. Are you offended? Are you scared you might suffer bodily injury? No. Lawyer is Sabrina Schroff, for those asking. She proceeds to argue that Sandwich Guy couldn't have impeded or interfered with the mission of high visibility crime patrol and prevention because he drew 24 officers to the scene. Now the parties are on the phone arguing over whether she was permitted to say, as she did, that Sandwich Guy was worried about a raid on LGBT's club's Latin night and what to do about it. So I guess we weren't supposed to say that during closing arguments. She expresses dismay at having been interrupted. Quote on the screen from Sandwich Guy about Latin night. These fascists are racists. Plays video. Point is that he did not, quote, succeed at stopping an immigration raid because you can't interfere with something that was never going to happen. And then he ends by stressing that the jury doesn't even need to figure out any of the verbs because the government can't prove the adverb, not without the ability to inflict bodily harm. Your gut should be telling you. Again, don't think this one was intentional. Throwing a sandwich is not a forcible offense. So I think she's referencing the gut joke and the food. Government says this isn't just a sandwich. It's the screaming, the cussing, and attempting to instigate. There's an objection, the judge says. Quote, I guess we're just going to interrupt both sides a lot. Quote, I do think, counsel, this is getting way too long. Remember this, the judge thought this was going to be a simple 2-day trial. The jury is entering deliberations now. And guys, court shuts down at 5 on the dot over there, so they left at the end of the day yesterday with no verdict. And then let's see any updates. Are we just lingering in curiosity territory? Oh, good question. So the question reads, the note says, quote, please define bodily harm. How is injury different from bodily harm? They're thinking about it. They're thinking through the elements, you guys. They are thinking about those, you don't even need to get to the magic adverbs because the intent to inflict bodily harm has to be there. So there we go. That is the jury question. So presumably they'll be deliberating a little bit longer, but maybe that's all they need to get over to come to a decision. And maybe I don't know what the balance would be, but maybe some have made up their mind and some are just on the fence. I don't know. Tea leaves when it comes to jury questions. But what do you guys think? And good morning, good morning. What is everybody having for lunch? Everybody's got to get a sub. Oh, man. Oh, I'm sorry for scaring you awake when the stream started, Aaron. My bad. Hey to Mavka. Hey to Peter. Hey to KP. Velvet Savage, if you haven't surmised, because I'm getting to this like 10 minutes late, it is about a sandwich being thrown. We could pull up the video. Let me find the video. And it was initially the government tried to bring in an indictment. They wanted a grand jury to indict on felony charges. Grand jury declined. So now this is a misdemeanor trial. Okay, so here is, oh. And then he runs. And then he's apprehended. So this is what this comes down to. And on day one, we had the officer that gets hit with the sandwich saying that he could still smell the mustard and the onions and that there was a piece of onion on his radio antenna later that night. But by other evidence and even kind of by the video, it suggests that the sandwich never unraveled and never opened. So there's some all right, it's clear that the defendant, Sean Dunn, threw a sandwich. Nobody's disputing that he threw a sandwich. The issue is did he do it with this intent to impede law enforcement? Did he do it with intent to cause bodily injury? Are those elements met? And cool. The video should be enough. But then this officer gets on the stand and has to hyperbolize and say all these things that I would say are demonstrably not true. That sandwich, to me, by all accounts, especially taking into the context from the text descriptions of the trial, that it looks like they end up seeing on camera images that the sub's still intact, wrapped up. Why did the officer need to get up there and make up those details? So it's like we cannot get through a trial without an officer getting up there and making something up. Jay Money says flinging the footlong's diabolical. I think it was a salami sandwich. So it's apparently a Subway sandwich. I want to assume it has onion and mustard on it. I don't know. I don't know if we have the actual breakdown of the ingredients on the sub. Oh no, EJF says someone gave me a thumbs down. Maybe they're telling you to go south. Hey Turkisha. Hey to Dizzy. Hey Paulette. Hey J-Town. What in the sandwich is going on here? We're gonna see. Let's see if they just go back into deliberations, if we get an update on how this question was answered. Because I want to know. Nope. So no update. So I would imagine the state is offensive touching. Remind them about offensive touching. I would love to hear both sides argue to the judge on this. But it's hopefully the reporters can hear that. But it's unclear because sometimes they end up approaching at sidebar and doing it that way. So I would say Brooklyn, I'm sure there could be time available for the sentencing, but if this is somebody with no record and this is a misdemeanor, so if he's convicted, I think jail time would just be disproportionate. Unless DC has a history of imprisoning people with no records, then I guess the state could argue it would be consistent and the judge would still have some discretion in deciding. But I think it's crazy for any situation, right? If you have, especially there's like an indication that like this question sort of indicates that the jury is not buying an injury was affected. That maybe it was just offensive touching. I would not approve of jail time for something like this. But it you never know. You never know. Barbara Open Hope says, we all know throwing a Jersey Mike sub is a hate crime. Yeah, but Subway, they have that sugary bread that they had the issue with, right? They were sued for their bread having too much sugar in it or something. And then I think they've been sued for like, let's see. Let's see if we can get like a Wikipedia list of Subway lawsuits. Oh, let's read this. There's a blog that says 15 of the biggest chain restaurant lawsuits of all time. All right, so let's just go through this. This will be a fun distraction while we wait for an update. Can I put this in reader mode? Because this kind of sucks. All right, so let's do it this way. So Jack in the Box, their number one is Jack in the Box's E. coli outbreak. I mean, that kind of seems serious. Ended up in settlements of more than 50 million. The McDonald's hot coffee incident. And we're going to talk about a different McDonald's hot coffee incident. And maybe we could just go into all of that right now while we kill some time. But I think everybody remembers, like, this was like 20 years ago, I feel like. The McDonald's hot coffee incident, where the temperature of the coffee was too hot. And I think some of the commentary and discourse was, you should expect to be careful when you're carrying any hot liquid. But I think this changed the standard of the temperature that you're serving a product at shouldn't be exceeding a certain temperature. So, because she actually got really badly burned. They mentioned a Starbucks lawsuit in 2025 after someone was burned by hot tea. So a former manager. Oh, so that's the Starbucks one. Oh my God, someone sued over broken ice cream machines at McDonald's. That's kind of funny. So McDonald's was sued for $900 million over broken ice cream machines. Burger King had to pay nearly $8 million because of a slippery floor. You got to put those signs out. 50 Cent sued Taco Bell? How did I miss this? Okay, so it's safe to say that 50 Cent probably still isn't a big fan of Taco Bell. In 2008, the rapper, whose real name is Curtis Jackson, sued the Tex-Mex chain for $4 million after it used his name in an advertising campaign without his permission. Oops. Part of the 79, 89, 99 cent Why Pay More campaign included an open letter addressed to Jackson, encouraging him to change his name to 79 cent, 89 cent, or 99 cent. Do you remember when things were that price? And to come to one of its restaurants to wrap his order. In return, Taco Bell would make a donation to charity. But Jackson was not happy about the campaign. He filed a lawsuit against Taco Bell, claiming that they used his name without permission, which led many fans to believe he was working with the fast food chain. And that's usually the issue, right? The issue might not be specifically that you're harming Jackson, but that you're misleading consumers. A reasonable consumer could interpret that advertising campaign to mean that Curtis Jackson was endorsing or promoting Taco Bell in some way. So they settled. Everybody covered their own legal fees. KFC, a salmonella case. Yuck. Red Lobster's $65 million lawsuit against Thai Union. What was this? So there was a highly publicized failure of the endless shrimp deal, for example, which ultimately cost the chain around $11 million. Then there was a bankruptcy filing brought on by factors like increasing operational costs and the COVID-19 pandemic. In 2024, after emerging from bankruptcy, Red Lobster's new owner, Fortress, attempted to recover some losses by suing former minority owner. Okay, so Thai Union was the former owner. According to Fortress, Thai Union owes the company the money because it did not hold up its end of a financing agreement, which would have supported Red Lobster with liquidity management. Thai Union, however, sounds just like contract law, maintains that the agreement only applied to a specific time frame, and it is therefore not liable to make payments. So as of the time of this writing, the case was still ongoing. So there we go. Mushroom burns. Let's refresh over here in court before we, what the heck, mushroom burns? All right, so there we go. We have an update. So the government takes some time to think about the definition. The defense says this is simple. Bodily harm means harm to the body. Government comes back and says basically that body harm can include injury and offensive touching. I told you they'd want that offensive touching. So they want to remind the jury of offensive touching. And the defense just wants bodily harm means harm to the body. So, and Molly also says, who knew it could be this complicated? Not the judge, not me. So there we go. There is our update. Presumably they'll come to a resolution and we'll get another update on how the judge instructs. So we'll check back. What is going on with this mushroom burn? Speaking of all these other restaurant and food lawsuits. So Olive Garden, $1 million sought over mushroom burns. When you head out for a meal, the last thing you want to end up with is serious burns. But unfortunately, sometimes that's exactly what happens. In fact, according to the law offices of Sean M. Cleary, around 1,200 burns happen in the food service industry every single year. We mentioned 2 earlier cases with hot beverages, but food is also a risk. So in 2019, one woman named Danny Howard sought damages of up to $1 million from Olive Garden after she ate a stuffed mushroom that was too hot. So they came to the table and she got like the pizza roll, the bagel bites, like when you bite into something and it's still too hot on the inside, it's superheated on the inside. Oh man. And I can picture the shape of that burning like the roof of your mouth. Oh goodness. According to Howard, after she bit into the mushroom, her mouth started burning and she started choking. She then claimed she went to the hospital struggling to breathe, and she was then moved to a specialist burns unit. Dang! As a result of the incident, Howard filed the lawsuit. She claimed that none of the Olive Garden staff had warned her in advance about how hot the mushrooms were, so she sought between $200,000 and $1 million in damages. And for what it's worth, this seems like an amount that would cover those hospital bills. Right? This does not seem like somebody going out there seeking, $70 million. I would imagine the bills going to a specialist burn unit probably higher than this and probably pretty close to this. So, I honestly wouldn't be surprised if it exceeded this. That's scary. But I think that's the product of if they're like microwaving their food. Like you're superheating it on the inside, it wouldn't be as hot on the outside as like if something came out of the oven and was cooling in the air as it was on its way to being carried to the table. A microwave will superheat the inside of something. So, yeah, and roof of the mouth burns. Oh. And you can't ignore that. When you get like a roof of the mouth burn, it's like, I can't ignore that. And I keep messing with it. So, not a fun time. IHOP had a wage transparency settlement. Cheesecake Factory had a wage transparency settlement. Denny's had a discrimination lawsuit. So Denny's near me closed down. We don't have a Denny's near us anymore. In the 90s, Denny was called out for racism in a big way. Black customers of the chain claimed that they'd been asked to prepay for their meals before they were seated. For example, and one former manager of the restaurant chain claimed he'd been asked to close down the restaurant if it had too many Black customers. So this sounds like it's coming down from, it's not just one store doing it, because you have a manager saying somebody was asking them to close it down. Unless it was just this store and they're trying to say somebody else told them to do it as an excuse. And that's just scratching the surface. Thousands of Black customers made complaints against the chain. Well, I would imagine that's more than one restaurant then. So this seems like it's top down. Somebody higher up is making it like a store-wide policy, region-wide policy. Those complaints turned into lawsuits, and Denny's ultimately agreed to pay out more than $54 million in settlements. In total, more than 4,300 claims. 4,300 claims were filed by Black customers. The lawsuits didn't just result in monetary action. Denny's parent company, Flagstar, denied discrimination, but also agreed to investigate the issue by sending in Black actors posing as customers to it. So they mystery shopped. The settlement also dictated that any money left over would be donated to civil rights nonprofits. So I never heard about this, but I would have been, I mean, depending on when this happened, I would have been either not alive or very, very young. But that's a lot, because this sounds like it's beyond a region. So that's crazy. We've got Subway paying $30.9 million in major FACTA lawsuit. So the Fair and Accurate Credit Transactions Act. Under the act, companies are required to take appropriate measures to protect their customers' sensitive financial information. Oops. So what did they do? This means things like obscuring key credit or debit card information on any paperwork and not, say, printing it on a receipt for anyone to find. And yep, as you probably guessed, that last part is exactly what Subway did. So you ordered something from Subway back in the day and they had your credit card number just in full printed on the bottom. Well, Texas Roadhouse had to pay $12 million over age discrimination. For workers? Okay. So the legal action was filed on behalf of hundreds of workers, all aged 40 and above, who claimed they had been denied front-of-house job roles due to their age since 2007. Evidence presented in the case included job applications labeled with yellow stickers noting that some applicants were too old or too chubby for the role. Well, you know what? I always appreciate when there's a paper trail. So HR was doing a not very HR thing. You know, it's my opinion that companies have HR to reduce liability and not actually be a resource for the humans that work there. But here, their HR team was like, let's just lay it out plain and clear that we're denying this person because of their age or their body weight. So at least they left the paper trail. Following the lawsuit, Texas Roadhouse agreed it would change its ways and overhaul its hiring practices to make them more inclusive. But you can't please everyone. In 2025, the chain came under fire from American First Legal, which is claiming that it is now discriminating against white men because of its diversity, equity, and inclusion policies. Panda Express settled a class action lawsuit for $1.4 million over delivery costs. Delivery costs. Okay, so misleading customers. So there you go, consumer transparency. The issue was they were accused of misleading customers over the delivery fees. So the company advertised low-cost deliveries, but then proceeded to add service charges to delivery orders. Panda Express did not admit that it had done anything wrong, but it did agree to settle quickly. So, and any impacted customer could apply for Panda Express vouchers or a $10 cash payment. So if you guys want to read this in detail, any of the ones that we skimmed through, here is the 15 lawsuits list dropped in the chat for you guys. It should be not behind a paywall. Oh, that was a time. Let's see. All right, so no update with what the judge went with. Let's check. No update from Celine either, although let's see if there's like a new tweet instead of a thread. Yeah, so no updates on what they're actually instructing the jury. So hold on. This was 34 minutes ago. We hear that there's a note. And then about 20 minutes ago is when we get the report on what the question actually was. So they've been figuring this out for 20 minutes so far. at minimum. And hey to everybody that's joining now. We are just, jury has a question in the sandwich trial. We are eagerly awaiting an update to see how the judge answers the jury's question. Oh boy. I see Amy's in the building. Thank you, Amy, for the reminder for everyone to hit that like button. Throw a sub at it. Just do it an odd number of times so it stays liked. Guys, also make sure you're checking out Amy E. Got a ton of stuff on her channel. And she's doing her videos as premieres. That way there's a chat feature. So even though it's not like a live stream, it still has the thing that I think matters the most, the chat, the ability to hang out. So show some love. Come hang out on her next premiere. Hey to Adventure Aaron, good to see you. Barbara says, as a chef, I have no idea what mushroom burns are. Probably because you aren't relying on a microwave. That would be my guess. That would be my guess. Because I'm thinking of I think the best example is the bagel bites. You bite into a bagel bite and it's not going to be a good time. Hot Pocket burning in one part and then ice cold on the other. So, let's see. Yeah. Julian says medical bills are insane. Yeah, I don't think that Olive Garden, the 200K to 1 million is unreasonable. And it seems like she went to the hospital and then they transported her to a specific unit. So obviously that was a 1-paragraph summary, but with that information, it seems like she had an injury. So, hey to 9 Mayflowers. KP says, I always thought Denny's were racist. My friends always used to want to go to Denny's like when we'd be done with an event. So it'd be like 2 or 3 in the morning. And we had a great diner, like mom and pop diner that was 24 hours. But nobody ever wanted to go there. And we'd always end up at Denny's and we'd be there for 3 hours before we'd get food. And it would drive me nuts. It would drive me nuts to the point where I would just start going home. So I don't have a pleasant experience with Denny's for that 3 a.m. time frame. And I don't know if it's because they looked at us as a bunch of like rabble rousers coming from the club at the end of the night or something like that, and they didn't want to serve us. But like, I worked in the service industry. I tip well. So their loss, their loss. But I don't know. And then Mel remembers that from Denny's. I think I was a wee little tot. And MJ's also saying a Denny's in Oakland closed after 50 years due to theft. So is Denny's just becoming like, are they phasing out? I wonder if they're phasing out. I know they started to do the ghost kitchen thing where they're doing business through DoorDash with like a different name, like Just Wings, I think. Are they the ones that do Just Wings? They have a Burger Den and a Just Wings, I think, are ghost kitchens for Denny's. I could be mixing up with another chain, but they're doing something with ghost kitchens. Yeah, that's one of the Subway ones, Barbara. Getting sued because the footlong wasn't actually a footlong. Let's see. Let's refresh this. Nothing from Celine. And I don't see anything from Molly either, so I guess they're still trying to figure it out. So, yeah, who knew it could be this complicated? Who knew? But yeah, Subway lawsuits. I think this is it. Shorting. Oh no, this is the meat one. They weren't putting enough meat paws on the sandwiches. So this was 2024. This is the most recent one, and I remember this one. They were accused of using photographs and advertisements to make it appear that the steak and cheese sandwich contains at least 200% more meat than the actual sandwiches the customers receive. And you guys know how that goes, right? The picture looks amazing. It's like super tall. Sandwich is all like densely packed. And then you get the sandwich and it's like thin little covering. Thin little covering. So, did this one close out? So no update, at the time of that art. And it's giving a Subway ad in the corner, you guys. They got us. They got us with the ad. There was a lot of meat in that advertisement video. I doubt if I went to Subway right now, my sandwich, and it doesn't need to look as pretty and presentable, but it needs to, what you order as a product should match the contents of what's being photographed. Like McDonald's can't just add extra cheese to make their pictures look better. They have to use the item as it would be served, but they can do tips and tricks to make it look better when they're photographing. So obviously, professional staging, good lighting, you can use like a blowtorch to make things look extra melty right before you take the picture, all these different effects, but the core product has to be the product that would be served. And I don't know, that Subway video that peeked into the corner just looked like it had a lot of stuff on it. So, probably a waste of the ad spend targeting, I would say. Did that make anybody want to go get Subway? Or was that a waste of their advertising money? Let's see. Subway lawsuit footlong length. Oh. Forbes did a deep dive. Let's see if we get, okay, I have 2 of 3 free articles left. So we can read this one. So from Forbes, why the Subway footlong lawsuits fell short. You may recall the lawsuit against Subway restaurants for selling 12-inch and footlong sandwiches that were allegedly less than 12 inches long. Case, lots of attention. The lawsuit's denouement turned out to be far less titillating. Subway agreed to settle the case for about $500,000, almost all of which goes to the plaintiff's lawyers, plus some minor changes to Subway's practices, such as additional disclosures to consumers. Ooh, they have a settlement website. Oh, it doesn't look like they have their stuff active anymore. So it was subsettlement.com was the URL they used. When the settlement was announced, some folks found it hard to believe that Subway could settle such a major case for so cheap. As the details have emerged, however, it looks like the plaintiffs were lucky to get anything. In the court's final approval of the settlement, the judge explains. So this is the judge's from the judge. So the doctor's associates' own testing show that the vast majority of bread sold in Subway restaurants was at least 12 inches long. Oh. Okay. And that most of the bread that happened to be shorter than 12 inches was less than 1/4 inch shorter. So this is the judge's words, I guess. Also, all of the raw dough sticks used to bake Subway bread weigh exactly the same. The dough sticks arrive at the restaurants frozen and are then thawed, stretched, allowed to rise, and baked. Due to natural variability in this process, the final loaves may have slightly different shapes. Some loaves will be slightly shorter and wider, but because all loaves are baked from the same quantity of dough, each loaf contains the same quantity of ingredients. So there we go. That's actually interesting. All this time, I thought they were caught red-handed, purposely shorting people, and the judge said no. The amount of meat and cheese included with each sandwich is standardized. Thus, a sandwich that is slightly shorter than 12 inches contains the same amount of meat and cheese. And again, this was before this newer suit about the steak and cheese. So, and wasn't there a change where Subway said, oh, we're going to start preparing some of our meats fresh rather than doing the pre-portioning? I don't know if they did that for the steak sub that the lady in the not enough meat lawsuit would order. But like, and like with the tuna, they use like a little cookie dough scoop, and like scoop the tuna on it. But that could vary too if the individual is doing like a level scoop versus someone that's doing a heaping scoop. Oh yeah. No, we like our Alabama friend. Hannah, right? It was Hannah? We like our Alabama Subway friend. That's the only Subway we want to order from. Barbara says this is how we get Skynet. It starts with ads. Uh-oh. Uh-oh. But yeah, so they're saying that it's universal. And I think they changed this as part of their campaign since the footlong length suit. That now they advertise they wanted to do fresh cut, more deli cut. I don't know if that really was the case. Meat, fresh to order. It is theoretically possible that a sandwich made on a slightly shorter loaf would contain a slightly diminished quantity of toppings. A sandwich that was a quarter inch shorter than advertised might be missing a few shreds of lettuce or a gram or two of mayonnaise. This is all the judge's language. This is a quote. So the judge is getting super specific. However, Subway sandwiches are made to order in front of the customer, and if the customer asks for more of any particular topping, the employee making the sandwich will add more of that topping to the sandwich. So the court summarizes, as a practical matter, the length of the bread does not affect the quantity of the food the customer receives. What is it? It isn't the size of the boat. Oh, man. So what problem did the lawsuit attempt to solve? Most customers got what they bargained for, and those who got shorted still got the same nutritional and caloric value as if they'd gotten a full-length sandwich. So there we go. There we go. There we go. Haley. Shout out to Haley in Alabama. Yeah, it is a bit Twilight Zone-y over here. We're just filling time as we wait for a response to this jury question. And maybe we won't get one. Maybe we'll just be stuck in definition purgatory. Nope. I mean, maybe they went back to deliberating? Because this is kind of a long time at this point. Like, typically, maybe this judge wants to go into greater detail, but usually the judge will just defer back to exactly how it was read in jury instructions. Not quote either of the attorneys from their closing arguments, but go back to the jury instructions that the judge read and just reread that portion. So, and speaking of portion control, yeah, mayonnaise got expensive. The Nem says 2 grams of mayo is almost as valuable as cookie. Not that white stuff, the other white stuff. Yeah, sorry, Shayna. We are talking about all sorts of food lawsuits. So I guess since we have time to fill, I mean, I'm thinking I want an answer before we wrap this one up nice and tight like a dangerous sub-weapon. I do want to get the judges how he answers the jury. If they go back to deliberate, I think we can end this one out and just pop back on when there's another question or a verdict or we're hopelessly deadlocked. We are hopelessly deadlocked. But I was going to do another what in the about recent fast food stories. And I guess we'll start with this McDonald's hot coffee toss. And I mentioned yesterday that the 3 stories I pulled, they're all in different phases. So the first one we're looking at is something that just happened, and there's a video going viral of it. And as of the time, the video I got from Daily Lao, but others were talking about it, they're looking for who the woman is. So the issue was that this woman was waiting for an hour to get her.
She said perfectly and apologized to somebody for being here over an hour. That's what you can have. Yeah, within 20 minutes. Now, catch that hot ass off. It's showing that the order was already made. Watch this. Ma'am. Ma'am, when we pull it up, if it's after 10:15, the food's automatically. I was already here, so it doesn't. Why is your order in the order? It just canceled right now. Ma'am, your order was, you got your coffee, that's all of you were charged for. Your refund would take up to 48 hours. And she told you. Why too, because it took your 3 days. Yes, it is. I got to come in and get the order. So that means y'all got to exchange, take the amount out from the coffee and give me a different price. So that means you didn't charge me for this. It automatically refunds the food after 10.
So this is max volume, but it sounds like when you order something through the app, there's this disconnect. And I think it is really frustrating. I think it's a poor customer experience, but there's a disconnect when you order something through the app. And all of these companies want you to order through the app. But when there's an issue, the app just takes you to like frequently asked questions. You can't actually get customer service help, at least in a simple, logical way through the app. So intuitively, you think, well, let me talk to the human person in the store. And then in the store, they don't have access to dealing with the payment processing system where the payment was put through the application and not through their individual store's point of sales. So I think that creates a ton of friction. I think that this is consumers deal with it because they still want to patronize these restaurants, but I think it causes issues all the time. So it seems to be an issue where there's a refund for one reason or another about this order, maybe in relation to the coffee or something else, but the refund that was given for the product, it has to post through from the payment point of sales associated with the application. So then this woman ends up taking the lid off the coffee and going like this and saying, it sounds like she says F you. So depending on how hot the coffee was, you do hear the worker screaming. So yeah, you can't fight the friction.
So automatically, you got charged for the coffee, but sandwiches are going to be refunded. Ma'am, I had that and you're not listening.
I'm listening.
No,
You got to
you're
say,
trying to
we
argue
take this
this
amount
amount.
of home,
Ma'am.
and we're going to exchange that with the food.
Ma'am, she
You
was
said
told
properly
that.
and apologize to somebody for being here over an hour.
Ma'am.
That's what you
You can have
Yeah,
everything.
within 20
I'm not
minutes
gonna
right
keep
now.
going.
fuck you. Now, catch that hot ass coffee.
So there we go. And this was the third one I saw, and I don't know if the algorithm was serving them to me because we were talking about sandwiches or what. The next thing that came up on my news ticker, and it's just like a whole, like the fast food world is crazy with all of these stories that seem to relate around things not moving quickly. So this is a local story for me. This is in Brevard County down here in Florida. And again, let's do the reader mode because it's always, they're trying to give us these advertisements. I don't want them. So Brevard man convicted. So again, we're at a different stage in this one. You know, with the McDonald's one, we're looking for the individual. With this one, we have a conviction. So Brevard man convicted in threat to Taco Bell workers who asked him to speed up his order. So this individual was apparently maybe taking too long, either in the drive-thru, I guess we'll see, or at one of the kiosks. They said, come on. And then it got ugly. So what happened? And I thought very Florida story. A 41-year-old man who pulled a gun on workers at a Taco Bell in Satellite Beach after being asked to hurry up and complete his order now faces decades in prison. Brian Bahana, Bahana, was convicted on Halloween of possession of a firearm by a convicted felon and was remanded to the Brevard County Jail Complex pending transfer to state prison, pleading no contest. He was also convicted on October 27th on charges of aggravated assault with a firearm, possession of a firearm by a person subject to a protective order for domestic battery, and another count of possession of a firearm by a convicted felon. And sentencing is set for the 3rd. He could face more than 30 years in state prison for the convictions in those two cases, the state attorney's office said. So this incident was June 25th, 2025 at Taco Bell in Satellite Beach, Florida. Patrol officers were called to investigate reports of an armed disturbance after a 911 caller said a customer was circling the restaurant in his car waving a handgun. A worker told police that Bahana pulled up to the drive-thru window, where he mulled over the menu, prompting the worker to ask him to pick up the pace. Because there were other customers behind him, prosecutors said. Police said Bahana then brandished a 9mm Ruger handgun, telling workers not to rush him and that you don't know who you're messing with. The incident was captured on security video. Officers arrived after Bahana left, but using a license tag number given to them by the staff, tracked Bahana to a rented room in a South Patrick Shores home. Warranted searches produced 3 handguns, including a black and blue Ruger matching the witness's description of the gun at the restaurant. Police also found rounds of ammunition loose on the floor and a box of 42 rounds of ammunition on top of Bahana's dresser. So there we go. So crazy. It's like road rage, but in the drive-thru, right? Like it reminds me of road rage, but in a drive-thru. Did I ever tell you guys the cat lore? I think I've mentioned it on stream before. This is also like a club let-out night. My friend was driving and drove up on the curve And I feel like it was a guy, not a girl. So this isn't a girl that doesn't know how to drive that drove on the curb. This was a guy. But the way this Burger King's drive-through was set up, it was like curb, and then there was a dip, like a very steep dip. So in driving over the curb, wheel goes all the way over the curb, tires completely all over the curb. And then the frame of the car is now sitting on the curb, like the tire is not touching ground. So they can't get out of it. We have to get towed out of this Burger King. And you know what? The Burger King didn't take issue with us. They didn't tell us we have to get a move on. We have to pick up our pace. They were really kind. I think they gave us free French fries. So shout out to Burger King. This was like 2016. So probably a whole different, it might not even be a Burger King anymore. But that's some cat lore with a negative turned into a positive drive-through experience with a Burger King. KP, thanks for being a member for 12 months. Says, I swear it's been longer, but whatever, Google. Yeah, I don't trust the membership count numbers. Because I'll see people that have been green. It looks like it renews their membership and starts them back at month 1. But they've been green and just changed their credit card or something. But thank you. That's a ton of support for 12 months. So big thank you here. We've also got Love Amy E with the super sticker. Thank you so much, Amy. And thank you for holding it down in the chat. Classy says YouTube be tripping for real. I think it just wants to like nudge people to not risk having the gap in time. I think that's kind of stupid. They should give a serious grace period, like 30 days, let people renew in peace. And Classy B's also generously gifting 5 memberships here. Guys, I had a great time. I've got to go catch up on some daytime news over at Classy's daily show because I've been busy in the mornings. I had a great time at Club Classy last night. If you guys found this channel back in the day when we covered the Jonathan Majors trial, again, another misdemeanor trial where there was no cameras. There were no cameras in the courtroom. So we had to rely on tweet reporting like this. And then we also got the transcripts and read through them. That was, really the first time I met a lot of you guys that are here today. And yesterday at Club Classy, I think it was Hollywood Co. submitted a song and had a Jonathan Majors bar in there. It was very, very good. Very, very good. I had a blast last night at Club Classy. That was a great time. But you guys know the drill. In addition to his weekly music shows, Classy also does his daily morning shows. And Classy, please cover the Imani Ellis and Cardi B thing. I was surprised. I mean, I thought it was the story itself, I thought was like, oh boy. But then reading some of the Imani Ellis's attorney's arguments blew my mind. Not in a good way. Not in a good way. So please let us know if you're going to take a look at that as well. Appreciate Classy. Also appreciate Amy E. When we're not hanging out on Amy's channel, she's always holding it down in Classy's chat. So appreciate both of you guys. Yeah, Barbara, cat reading aloud for us. My first attempt at an Audible book was reading court transcripts. So, all right. And Classy says, yes, Steph will for the Imani Ellis stuff. Because that was a mess. That was a mess. Oh, Bailey's 17 months. Holy moly. See, now Factual Lie is showing out here. She says, look, I got 17. So big thank you. That is incredibly long of a time to be a member. So big thank you. And using the message as a chance to remind you guys, don't forget to do the YouTube-y things. So while we're here, let's refresh on Molly. I think Factual Lie, you've been like in the bushes playing Sea of Thieves, I think. Maybe. Totally understandable. I think you mentioned the DLC involving the word riddled. And you've been preoccupied with that DLC. So that's very entertaining. My roommate plays Sea of Thieves. He co-streams with, I know the name of the host. Her name is Juicy something, but they play Sea of Thieves all the time. So now when I hear them really loud, right? They're gaming, so it's really loud. Okay, it's Guild Wars, not Sea of Thieves. Still good, still good. I was going to say, dang, you guys should connect and play Sea of Thieves together. Because they be so loud. They're playing. I'll hear screaming and I'm like, is everything okay? Oh, they're playing the game. They're playing the game. So, hey to Perfect Peace. Glad you can make it to Alive. Good to have you here. And Riddled Cove was the name of the new DLC. Oh, Riddled. All right. So I don't think any of the... Yeah, so I followed like 3 people that seem to be tweeting from the courtroom. This still looks like the most recent update, you guys. I feel like maybe they're just not gonna figure out what to say. Then they're gonna go to lunch. It's like 11:30. They're gonna go to lunch. Yeah. Deuces says, let's all hop on Guild Wars 2. A cat chat party where I wouldn't participate. I've never played Guild Wars. I'd probably be horrible. To be honest, GW reminds me of Garden Warfare, the Plants vs. Zombies version of like Call of Duty. Garden Warfare. I don't know if I played the second one all that much, but I definitely played the first version of that. I thought it was hilarious. I thought that was a great game. But that's what I think of when I see GW2. So, and it's free to play. Good to know. Good to know. And you guys, I mean, I don't mind at all if you guys want to use, let's see, let me get a link to the little Discord that we have. I don't mind at all if you guys want to use it as an opportunity to connect and coordinate and get together like a gaming party. That sounds awesome. So there is a link to the Discord in the chat. And you guys can find each other in there, figure out if you guys want to link up on a game. That would just be super cool. But I think, unfortunately, I think since they're not giving us an update, I think we should wrap this one up and come back next time there's a note. And hopefully that note will be a decision on, hey, we have a verdict. Or we're hopelessly deadlocked. We are hopelessly deadlocked. But it's been 40 minutes and we've got nothing. So maybe they're icing us out. So let's wrap this up. Sad to say. I'll throw up another stream that, you know, it'll be there when we're ready to go live, when there's a note that comes in. And again, just hit that bell so you get notified, because I can't predict when a jury is going to come in. It feels like, let me see if I can just find the GIF. Let's see. I think this is it. Let me get this video clip. Where he's trying to get this bus to get out of Rock Bottom and get back to Bikini Bottom. And the bus never comes. But the split second SpongeBob tries to do any other little thing that only takes a split second to do, the bus comes and goes. And the whole episode is just like tormenting SpongeBob. And that's how I feel when we're waiting on a verdict. As soon as I start doing something, there's going to be that update that the jury has reached a verdict. So this is what I'm going to look like until we get an update. That's how we're going to roll this one out. And Classy, are you going live? We can redirect over to you. If not, do you want to go live? Let me see if you've already got a stream planned. Let's see. All right, customizations. And then okay, sorry. Sometimes YouTube makes me, they don't just show me who's live or who has a planned live. I have to search names sometimes. Okay, I'm not pulling up anything for you, Classy, so I'm just going to drop your link to your channel in a second. And Dolly's coming up as live right now, doing Judge Simpson and Courtroom Roulette. So I think most of you guys like Judge Simpson. I love hanging out over there watching these. So we'll do that until we have a verdict update. We'll pop back on. And let me get Classy's link. Yeah, see, I see you have a live scheduled for 12:15 now that I'm on your wall. So a bit away from now, you guys, Classy will also be live. So there is the link there to his channel. And that's Eastern time, you guys. So what are we at? We're like 45 minutes away from that. So there you go. And Nick is in the chat. So how is this entire case not a night in jail and a fine? I mean, even with the conviction, I would not expect this to incur a serious penalty unless there's a record. I don't have any indication that Sean Dunn has a prior record. And I believe he used to be a government employee, so I would hope doesn't have like priors sitting there. But yeah. So, and then factual lie. I almost said factual O'Bailey's. Says Baker, Broken Baker is live. So let's drop the link over there. And Baker is doing the teen lovers trial, the one where the boyfriend and girlfriend are accused of killing grandma. So there's a link to that in the chat as well. And Nick says no lie from him today. He got home from a glorious 13-hour workday. Well, I hope that was an amazing time. And I know the feeling. So there we go, you guys. We're going to get out of here. This will redirect to Dolly, but there's a bunch of links in the chat for you guys to, you know, explore however you want to explore. And we'll get back together maybe in a few minutes, maybe in a couple hours. Oh, and Trakeisha says Devin Michaels trial. So that, you guys, that's a Pacific Coast trial. So they start later in the day. They're West Coast. So probably, I don't know, I'd imagine if they start at 9 o'clock local time, they're probably starting in like half an hour. But Flesh of the Gods, the source, has also been covering that. So there's another one to add to your radar. But there we go, you guys. See you in a little bit, probably.